Alrighty. So I'm not an attorney, not giving legal advice. Okay, do your own research. All right, I might have to put this in the beginning of my page, um, but this is actually rules of civil procedure, 601 and 602. Okay, um, this came off what we've been talking about, right? Paralegal, the versus paralegal, par. I cannot pronounce it at a particular time. I'm gonna have to read it to pronounce it, and it's not in front of me right now. But we have been talking about it previous, right? And this is my understanding. Don't mean it's true and false. I'm not an attorney. I'm not giving legal advice. But here we go.
Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. We want to look at a couple rules of evidence, specifically rules 601 and 602. And these have to do with witnesses, and that would include a party, who testify have to have personal knowledge. Okay? And how does this work in a debt collection lawsuit context? So let's take a step back. What are the purposes of the rules of evidence? And this is what Alabama Rule of Evidence 102, and everything I'll be looking at will be the Alabama Rules of Evidence. But it says these rules shall be construed to secure fairness. And then look at the highlighted part. To the end that the truth may be ascertained and proceedings justly determined. So let's just summarize that. It's to make sure that trials are fair and that the truth is reached. So let's look here at the actual rules. So Alabama Rule of Evidence 601, every person is competent to be a witness except as otherwise provided. The reason that this is worded this way is in the past there were certain groups of people who were considered incompetent to testify. So for example, spouses could not testify against each other. But now this is saying the presumption is everybody is competent, is able to testify, unless there's something in the rule. Well, let's look at the very next rule. Rule 602, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. And then that can come from the witness's own testimony. And if you look at the right-hand side of the screen, the comments to the Alabama Rule of Evidence 602. And the comments really sort of flesh out or help explain what's the idea behind this rule. So it says this is unchanged from the Federal Rule of Evidence 602, and it embodies the traditional first-hand knowledge requirement under which a witness is precluded from testifying to a matter about which the witness lacks a first-hand or personal knowledge of the facts. So before the witness can testify, a foundation must be established to indicate the witness was in a position to observe, and not only in a position to observe, but did observe those facts. So let's look at a couple examples. And we'll have a total of 4 examples. And then I'll tell you at the end if you want me to use some other examples maybe that you're dealing with. I'm happy to do that. So these are all in blue highlighting. Number 1. The question would be presented to you at trial. You opened up this credit card account. Yeah, whatever it is. Chase, Capital One, Bank of America, whatever it is. Well, let's think about it. 601 says you are competent to testify unless there's a rule of evidence that holds otherwise. Okay, so you should be able to answer this question. Rule 602 says you have to have personal knowledge about this. So the kind of the mental thought process would be, well, do you have personal knowledge of whether you opened the account? So this is not asking if somebody else opened the account or somebody else owes the debt. This is saying you opened this credit card account. Well, you're under oath, okay? And the judge is evaluating your credibility. And I would say that most of us, we are going to know whether or not we opened up a credit card account. So if you're asked that question, you say, I have no idea. Judge is going to be a little skeptical of that, unless there's a very good reason for saying that. I mean, you should know whether you opened up a credit card account in your name. So let's look at the second example. You admit that you charged on this account and you owe $3,467.91 and principal, interest, and late charges. Well, again, we start with the foundation. 601 says you're competent unless otherwise. 602 says you have to have personal knowledge. So do you have personal knowledge of the amount of the charges? Now, you may have incurred all those charges, but do you personally know the amount? Probably not. Do you know what the interest rate is from the beginning of the account to the moment that you're there in the courtroom? Or at least through the time that they charged interest, which may be trying to get it there at the courtroom. Well, probably not. Do you know the calculation? Was it 17.97%? And what was the daily balance or the monthly balance? Or how was the interest applied? Is that on a monthly basis, a daily basis? Do you know the calculation? If you do, then testify. If you don't, then Rule 602 would say we're not supposed to testify about that. So how about the amount of late charges allowed under the contract? Do you know that? Is it $15 a month? Is it $35? Can you still be charged late charges after the account is charged off? How about interest after the account's charged off? Do you know that under the contract? How about the calculation of the late charges? And take that dollar amount that the question asks you, $3,467.91. And remember, the company suing you has to prove that you owe this amount of money. Well, do you know how that's broken out into principal and interest and late charges? If you do, testify.
This being said, y'all, again, I'm not an attorney. I'm not giving legal advice. Do your own research. This is in any and all courts. Contract, constitution, civil, which is contract. It's in any courts. Magistrates all the way up to the Supreme Courts. Okay? This evidence of rules 601 and 602. Okay? In my case, it would probably be more along the lines of helping my friend out, family courts, and in my case of property tax, right? But it is good for every single area. For him, this is for debt, okay? So there you go.
Don't, then you would not be in a position where you would have personal knowledge to be able to testify about it. Let's look at two more examples. You admit Midland Funding owns the debt after it bought it from the credit card company, whoever that might be, Chase, Synchrony Bank, whoever. Well, again, 601 says you're competent unless you're not. 602 says you have to have personal knowledge. So here's the question. And remember, debt buyers have to prove that you owe the debt, and that's what these two slides, or these two questions on this previous slide were about. So they have to prove that you owe the debt and that they own the debt. Because you didn't take out a debt with Midland Funding or Portfolio Recovery or Calvary or anybody else. So,
again, he's talking about debt, but you could do this as criminal and any and all other matters.
You admit Midland Funding owns the debt after it bought it from a credit card company. Do you have personal knowledge of whether Midland Funding bought your old credit card debt? Do you know that that's true? Now, if you do, then you can answer. If you don't, what would you say? What would be the truthful answer to the question, you admit Midland Funding owns the debt after it bought it from the credit card company, and you have no idea if that's true. You have no personal knowledge. What would be the truthful answer? Well, I can tell you what my clients will say, which is, I have no idea. I don't know. Because they don't know. They have no personal knowledge about this. So, what about this last question? This affidavit from the original creditor, so again, it could be Chase or Synchrony Bank, whoever your credit card company was, that says we bought the loan and all the records are 100% accurate, proves that Portfolio Recovery bought your debt. Well, again, 601 says you're competent unless you're not. 602 says you have to have personal knowledge. So do you have personal knowledge of who signed the affidavit? Can you even read the name? Who notarized it? Do you have personal knowledge of that? Do you know if the affidavit is legitimate or not legitimate? Did anything happen after the signing of the affidavit? In other words, I've owned several houses in my lifetime. I could say, on this date, I bought this house in Chelsea, Alabama. Well, does that mean I still own it? Well, I actually don't own it because I sold it. Okay, something happened after I bought it. So do you know if anything happened after the signing of this affidavit? And does the purchase agreement contradict the affidavit? So remember, the affidavit says all the records are 100% accurate. But does the purchase agreement down here say, by the way, we make no representation that any of the records are accurate?
Introducing new buttermilk biscuits in sweet and savory flavors, so everyone can have their perfect biscuit. Or add one on the side.
Are accurate. Well, that would be important to know, wouldn't it? Do you know that? Well, if you don't know this information, then how would you answer this question? And again, all I can tell you is how my clients have answered this in trial, which is say, no, I don't know that this affidavit proves that your company or your client.
Remember, y'all, it's for your property tax, right? You can use this with the attorneys coming after you. Okay? Even though this is coming from an attorney, you can do that from the bottom to the top.
Client bought the debt. I have no idea. And they say, well, it's right here in black and white. Well, I see there are words on a paper, but I have no idea if this is truthful or not. So, hope you found this helpful. Let me give you a couple of sort of closing thoughts here. If you know somebody that's dealing or maybe about to deal with a debt collection lawsuit and you think this would be helpful, feel free to share it with them. If you are not already subscribed, if you like this video, just click subscribe, and we put out videos every day, and hopefully you will find those just as valuable as this one. And this last thing is sort of my request to you. If you have questions, maybe you've been sued or you're worried about being sued in a debt collection lawsuit, and are there questions you've been asked or that you're worried or concerned about being asked? And you're like, well, how would these be answered? I mean, would I have personal knowledge of that or not? If you want to, put those in a comment